the advent of things like OSHA and others, companies started thinking about their employees and the atmosphere that they were working in a lot more, and started tightening down on what they allowed to happen. Frankly, the things that we did back in the early 60s, if I were an employee with a chemical company now and I did those things, I'd probably be sent to jail, at least be fired for sure. So the world has changed. My concern would be that while the world has changed for companies like the company for which I worked, it might not have changed for some of the smaller companies that they might. So what I'm hoping to do with this is encourage them in some way to do that testing of the environment in which their employees work, the environment in which neighbors are in, and encourage them to go out and do the types of testing that they find those chemicals that might be in the atmosphere that they aren't otherwise required to do. And I know there's been concern on the part of some folks in saying, well, this is material that's going to be secret. You're trying to hide information from the public. And I can tell you up front that the only thing that would not be readily available to the public would be those things that may be a trade secret. And that's typical in applications that companies would make with the DNR or the EPA or that type of thing. They will let those agencies know what those processes would be that are trade secret, with the understanding that that's not going to be public knowledge. The other thing is making sure that employees or neighbors in the area are protected, and that if they feel like they've been harmed, they can bring civil action against the company. So that's something that we do have in this bill as well. And in the first part of the bill, I've included a statement that says, and I'm just going to read this part, an environmental audit report and supporting documentation as described in sections so-and-so shall be available by court order or subpoena, and nothing in those sections shall be interpreted to impede or excuse the disclosure of normal regulatory reporting requirements for environmental compliance. So any findings that they make would be readily subpoenable.
Good morning, Mr. Chairman, members of the committee. My name is Trent Summers with the Missouri Chamber of Commerce and Industry, here to testify in favor of House Bill 1974. We believe this bill will help facilitate a more proactive and systematic self-policing for minor environmental infractions.
The end goal is to really protect the employees of certainly those smaller and medium-sized companies who may have not felt like they wanted to do something like this for fear of retribution from somebody like EPA or DNR. So giving them some measure of protection, I think, will aid in doing that.